All right, I think we'll get started here. Thanks everybody for joining us. We're here today with Leader Durkin, Representatives Patrick Windhorst and David Freeze, as well as Illinois State Police Trooper Joe Moon, who's also the president of Lodge 41 of the FOP. So with that, as usual, we will take questions via text message. So if you can please text me your questions at 847-529-6767. We will get to as many as we can today and then follow up as always afterwards. And on that note, I will now kick it off to Leader Durkin.
Thank you and good morning. My name is Jim Durkin. I'm a state representative from the 82nd District, Western Springs, Illinois, but I'm also the House Republican leader. In a prior life, I was a prosecutor, spending 7 years between the Attorney General Office and also the Cook County State's Attorney's Office. I spent much of my time at the State's Attorney's Office investigating and trying major felony cases brought to the Layton Criminal Courthouse, otherwise known as 26 in California. I'm joined today by my colleagues, Representative Pat Windhorst of Metropolis, the former State's Attorney of Massac County. Patrick has extensive experience prosecuting felony cases in Southern Illinois. And our new representative, David Freeze of Red Bud, Illinois. David is an experienced and well-schooled attorney and has a wealth of knowledge when it comes to local government matters. And lastly, we're joined by Illinois State Trooper Joe Moon. Joe is the president of the FOP Troopers Lodge 41. We are here to discuss House Bill 3653, the recently passed criminal justice bill that made major changes to our justice system in Illinois. The bill passed both chambers and awaits the decision of the governor. I am here to ask the governor to veto the bill. Now, the Democrats who worked on this bill and advocates have said over and over again over the last week and a half that this bill was fully vetted and it was everybody was aware of what was in the bill. It's just not accurate. Over the past summer and fall leading up to the lame duck session, advocates of this bill only revealed talking points, bullet points, but not the actual language. All we heard about were concepts. The first time we saw the bill in its final form was at the 11th hour of a lame duck session, at the end of a lame duck session. It was approximately 10 o'clock in the morning on the last day of lame duck session. And when you make changes to the criminal code of procedure in our criminal justice system and also correction system, words, not concepts or talking points, have real meaning that must be interpreted every day by judges and attorneys across the state. While we can decry the process of this bill, which was a failure, the real tragedy is the failure of the bill's substance. We are at an important time in the history of our state and our nation. We must thoroughly and carefully address police reform and criminal justice reform. It is the right thing to do. Changes to the statutes must always ensure the constitutional guarantees of due process. We can never, ever veer from that. But I also know that my record as a member of the legislature is one that backs that concept and one who believes that everyone has a right to a fair trial and that due process must be elected at all times. And if reform is necessary, I will get behind it if it makes sense. But however, at the same time, we must ensure that the rights of victims and the public must be balanced along those lines. The horrible crimes committed in Minneapolis, Chicago, and across the nation caused by bad actors in law enforcement must come to an end. It's not tolerated. And as a Republican, I believe no person should have to live in fear of their government. And we must address those issues to make sure that that is true. House Bill 3653 doesn't do it. In short, it is a confusing, inoperable, and contradictory attempt to reform policing and the criminal justice system. The legislature in its whole is a document that lacks clarity and will be unworkable for police, the judiciary, defense attorneys, and prosecutors. Those are the ones that work day in and day out to make this system function. They should not be left trying to decipher what the legislature has served upon them. And that's House Bill 3653. The elimination of cash bail and creating a presumption of individual recognizance in this form is misguided and will have an immediate negative effect upon public safety. Public safety is the state's greatest responsibility to its citizens above all. The elimination of cash bail basically says that we respect the honor system for violent criminals and gang members. Yes, the honor system. Now, I believe in second chances. I believe in third chances. I do believe that people can change, and we need to give everyone in society a chance to get it right, to help them move on in their life, to get on the right track. But I also know firsthand that there are violent people within the state of Illinois in our communities, people who operate within criminal organizations that take advantage of our society, of laws, and will use a gun instead of due process to get what they want. In 2017, the Chief Judge of Cook County implemented an order reforming how courts handled pretrial detention with the goal of reducing the use of cash bail and also reducing the jail population in Cook County. Predictably, this order has allowed violent offenders the ability to continue committing violent acts that have endangered this public when they otherwise should have been held under detention until their case was resolved. And now this bill will mandate that type of attitude throughout the state. Let me provide for you a recent example of how this flawed and a dangerous approach of allowing the honor system for criminals has worked in Cook County. Just recently, Chicago Fire Department Lieutenant Dwayne Williams was recently a victim of a much publicized daytime carjacking that led to his murder, all caused by the failed cash bail system in Cook County. The offense caught on video was shocking and horribly sad for our entire community. This man spent his entire life giving to public service, but was cheated by the very government he spent his years protecting. 2 men and 2 juveniles were arrested and charged with first-degree murder and carjacking. One of those offenders, Devin Barron, was free on bond when Lieutenant Williams was murdered. For the cases which he was free on bond were home invasion and kidnapping. Yes, he was out on bond on violent crimes when this murder occurred. Another defendant, gunman Jalen Salisbury, was arrested for Lieutenant Williams' murder, but was freed on a recognizance bond for gun charges and possessing a stolen motor vehicle. They should have been detained for those charges, but when this murder occurred, they were out on recognizance from a failed bail bond system in Cook County. This is reality. It's not isolated. I could spend another hour talking about individuals who have been released for crimes that they committed, which were violent in nature, were put back out in the street, and once again committed violent crimes and even murders. Now, the mayor of Chicago has also identified the bond court reform as a cause for the increased violence that's plaguing the city of Chicago. But let's not forget the following facts. Murder in Chicago increased from 495 in 2019 to 769 in 2020, a 50% increase. Carjackings in Chicago increased from 603 in 2019 to 1,400 in 2020, a 150% increase. Now in 2021, in Chicago alone, there's been 150 carjackings, with 3 more just last night. Public safety has and will continue to be compromised with this type of attitude and with these type of bail reform measures. The facts and figures don't lie, and the murders and carjackings will continue throughout this year. There is another provision of this bill which did not get addressed during the debate, one that is extremely troubling for victims of violent crimes. The legislation that was put together in this massive 700-page document, one provision states that a defendant has the ability to compel a complaining witness to appear and testify at a bond hearing. Rape victims of all ages, domestic violence victims, family members of a murdered loved one are all considered complaining witnesses. They are victims. A defendant must appear, under the law right now, a defendant must appear before a judge within 72 hours of arrest for a bond hearing. And often that arrest of the attacker happens not only with days, but hours or minutes after the offense. So imagine this. A bond hearing is ordered for a person that has been charged with rape, and the court orders that rape victim to appear at that bond hearing, which could have been hours or days after the attack, to stand in front of the judge and also within a few feet of her attacker. This is not how we should treat victims of crime in Illinois. It is morally wrong, and it also is in direct conflict of the rights of crime victims and witnesses under our Illinois Constitution. And that section of the rights of crime victims was amended in 2014, called Marsy's Law. And that says that victims have a right to be free from harassment, intimidation, and abuse throughout the court process. Forcing a rape and assault victim to testify at a bond hearing serves no purpose and only compounds grief, tragedy, and distrust in the criminal justice system. The bill is broken. Our criminal justice system has been weakened too much. I call for Governor Pritzker to do the right thing for law-abiding citizens and victims of crime and veto this bill. A compromise cannot be found by acting in the extremes, but a compromise can be accomplished if we actually sit and go through the actual language and try to find what is the fair and balanced approach to address an important issue: police reform, criminal justice reform. I've always been in that mode, and I will continue, but this bill does not get it done. It will compromise public safety in terms that we can never imagine. So I would like to turn it over now to Representative Pat Windhorst.
Thank you, Leader Durkin, and good morning. I'm Patrick Windhorst, State Representative in the 118th District, which is all or part of the southernmost 11 counties of Illinois. Before joining the Illinois House 2 years ago, I served for 14 years as the Massac County State's Attorney. As State's Attorney in a rural county, I've handled cases from traffic tickets to first-degree murder and almost everything in between. I've worked cases where I've pushed for violent offenders to receive a lengthy sentence in the Department of Corrections. I've also handled cases where I've agreed to keep people out of prison when a drug court or other form of rehabilitation is a better fit. I've worked with police officers, police chiefs, and county sheriffs to understand how they do their jobs. Law enforcement officers and the officers of the criminal justice system have an incredibly difficult job. HB 3653 will make their jobs even more difficult. The changes contained in this massive omnibus package of sweeping criminal justice reforms are full of double definitions of important terms and ambiguous language. The intended provisions and the unintended consequences of this bill will most certainly have a chilling effect on our ability to recruit and retain good police officers. Overall, House Bill 3653 will lead to reduced public safety and a decline of the ability of the police to do their jobs. One of our concerns is the end of cash bail, which we believe has major public safety issues. There are numerous examples from across the country, from New York to California, as to why ending cash bail is a bad idea. Under this bill, we have significant concerns that criminals who commit acts of violence and other dangerous crimes, such as robbery, burglary, and arson, will be right back out on the streets within days, able to victimize more people. This is not acceptable. What we're hearing from police officers, police chiefs, county sheriffs, and deputies, as well as state police troopers, is that they are concerned for their safety and the safety of their communities going forward. As for the safety concerns for officers, there are significant changes in this bill on the use of force statute, which will create uncertainty for officers going forward. Also, this bill allows for unlimited anonymous complaints against officers. It requires all complaints against officers to be stored in a state database forever, unless there's a change in law, with no opportunity for expungement of unfounded or frivolous complaints. These concerns are compounded by the process by which the bill passed. This over 700-page bill was passed in the Senate at 4 a.m. after being filed just an hour earlier. It was voted on in the House that same morning. Now, while committees had subject matter hearings on the bill leading up to the vote, the actual language of the bill was changed up until 3 a.m. on the day the bill passed. This process resulted in a bill with conflicting definitions and ambiguous language. An example of this problem is the newly created duty to intervene, a concept which most officers support. Now, remember, this bill is actually a combination of two bills: the original criminal justice omnibus bill, which was House Bill 163 then, and an expanded police decertification bill. These bills were combined in the middle of the night, and that included in those two bills was two separate definitions for the duty to intervene. This lack of clarity will also create uncertainty for officers, particularly given that an officer could potentially be decertified as a police officer based on that conduct. Our final remedy to stop this well-intentioned but bad bill from becoming law is for Governor Pritzker to veto House Bill 3653. Our caucus is open to working with law enforcement groups and criminal justice reform advocates to address inequities. However, a rushed omnibus bill passed in the middle of the night on the last day of the lame duck session of the 101st General Assembly is not how we get there. Governor Pritzker, veto House Bill 3653. With that, I'll now turn it over to Representative David Freese.
Thank you, Patrick. Yeah, I'm newly elected state representative for the 116th district, which encompasses all of Randolph County, Monroe County, part of St. Clair, and part of Perry County. As Leader Durkin mentioned, I'm here in Redbud. I've actually served on the city council for years before becoming state representative. And on city council, as you can imagine, we have to produce a budget and we have to balance our budget. And when this came about, I actually reached out to local law enforcement. I talked to our local police chief, and one of his big concerns is the fact that this is a unfunded mandate. He's not opposed to body cameras. You know, I talked to him at length about this. He's convinced he does his job right. His officers do their job right. He's not concerned about body cameras. He's got no objection. The problem for every other small municipality, we just can't afford. The state should not enforce spending mandates on municipalities of this nature. Another problem is the fact that an officer, if he is involved in an incident, he's not going to have an opportunity to review the body camera footage before generating a report. This is going to put that officer in a terrible situation, because imagine yourself in a very high stress situation where you're involved in an altercation or perhaps a shooting, you got adrenaline flowing. And if you do not create or generate a report, which is identical to the footage on the body camera, that's going to put that officer, he's going to be subject to disciplinary proceedings and possibly that come along with this. Again, I question why the state legislature puts this additional burden on small municipalities, but they just do not have the funding to do this. Finally, an additional funding issue is this is going to cause additional funding problems due to FOIA requests. I can't imagine all the FOIA requests that are going to come into local police departments. In addition to, if there's court proceedings, you know, you're going to have requests from all kinds of court proceedings that involve incidents. Again, this, as Patrick and Leader Durkin mentioned, this must be vetoed by the governor. We've got to have an opportunity to rework these issues. Redbud and every other municipality in my district that is just not in our budget. We cannot afford this. Thank you for your time. With that, I turn that over to Trooper Joe Moon.
Thank you. First of all, I want to thank Leader Durkin for inviting me to this press conference. My name is Joe Moon. I'm the president of Illinois Troopers Lodge 41. Troopers Lodge 41 represents 1,587 active troopers in the state, also 1,669 retired officers, troopers, many of which are still in the ranks for different sheriff's departments and municipalities. So I want to first explain the fact that Troopers Lodge 41 had no part in seeing the 700+ page legislation that came out. There's a lot of misconception out there that law enforcement was involved. In fact, law enforcement wasn't involved. They were made aware of some concepts that were out there, but had no physical input. And it's apparent by the legislation that was passed. The legislation that was passed has law enforcement has serious concerns about. We didn't review any of the language, and because of that, we would ask that the governor veto the language. There are good parts of the legislation. Not all is bad. And I want to make it clear, law enforcement in the state of Illinois is not opposed to police reform. Police reform is not a bad thing when it's done correctly. And the 700 plus pages of this bill, unfortunately, will put citizens in Illinois at risk. Some of the non-custodial arrest changes for certain misdemeanors. And I personally want to thank Leader Durkin and the Republican caucus for standing with law enforcement and the handful of Democrats that came over and voted against this bill as well. I will say that a portion of the final bill, that the 700 some pages that went out, in the decertification and licensing part, we were trying to work. Law enforcement was trying to work with the Attorney General on. However, before that could happen, this was all rammed together and shoved out in the lame duck session for a vote. So that's unfortunate. I will tell you that because of this, I've had many members call and express their concern about continuing, if they're close to retirement, about continuing to do this profession without the support of the state of Illinois. I've had new troopers reach out to me and say, you know, if this bill passes, they will have to seriously consider for their safety and for their family continuing to do this job. So there are severe repercussions if this bill passes. And, you know, on behalf of all of the troopers and retirees that I represent, I would ask the governor to veto this bill. Thank you.
All right, thank you all. We have several questions. We'll get to as many as we can. First question, Dave Dahl, WTAX. What level of reform would you accept?
I can answer with some of the points. Trooper Moon, I believe, hit on some of them already, that things that they're in the bill that are acceptable. I mentioned the duty to intervene in my presentation. That concept is something that's supported broadly in law enforcement. It's just a matter of the way the bill was constructed that creates a problem. There was additional aid for crime victims and crime victims compensation that was supported. Whistleblower protections, first responder deflection was included. Also, a couple body cams and new training are supported, but there has to be a funding mechanism, especially for smaller jurisdictions. And then again, the police officer certification or decertification structure. There was efforts made to clean that up or to fix it. Unfortunately, as was mentioned, was thrown in at the last minute before those changes could be finalized, and here we are with it. So it's not as if our caucus or we're saying that there's no reform we're going to accept. It's just a matter of making sure it's done the correct way.
Thank you. A little bit of a follow-up to that from Dave Dahl. How do you oppose these measures without coming off as unsympathetic to the people supporting them? And also, there sure are plenty of alleged bad apples out there in Minneapolis and Kenosha and Chicago. What is the impact on how effective your message is?
Well, I think what we are expressing today is that there's a better way to go about this. And this bill in its form does not get the job done. It does not give faith to the men and women of Illinois that they will be made safe. It does not give confidence to the men and women, the 99% of the men and women who wear the badge, who do the job. They're doing it honestly and they do it nobly. They are demoralized. So I will say this, at anyone in law enforcement, whether they are on duty or off duty, commits a crime, they need to be held accountable like everyone else. Murder is murder. And what's happened up in Minneapolis is a tragedy. It should never occurred. And that police officer needs to be held accountable for what he did. Every police officer, if they are going to break away from their mandate and do things that are in violation of the law, they are no different than anyone else, any other citizen. But you can't do it under this form. And I will just say this, that the people that were involved in drafting the bill, I'm not sure if they understood all the concepts that are in it, and not maybe the concepts, but the way it was drafted. Pat will know that when we're in a court, we have to go and we have to wordsmith. We got to look through every word and we have to use it and try to determine what exactly the intent of the legislature was. Words mean something, not concepts. So the way that this bill has been put together with not only just the police reform, but also the certification issues, it creates a very inoperable, inconsistent document that will be, if not impossible, very difficult for anyone in the law enforcement business, judges, defense attorneys, prosecutors, and even the pretrial service officers to be able to figure out what the heck this means. It just doesn't work. I want something to work. I want to be with a good police reform bill. I've done this in the past. I've done it years ago when our death penalty system was collapsing. I will keep an open mind. I will work with the governor. I will sit with the governor. I will go through this line by line with him if that's necessary. But this would be an absolute travesty to not only law enforcement, but to law-abiding citizens of Illinois, because this is not going to protect our public, particularly at a time when Chicago is the murder capital of the United States, and we clearly are the carjacking capital of the United States as well, and that's not going away soon.
The federal courts don't use cash bail. You're either held awaiting trial or you're home. Why is this bill different or, in your opinion, worse?
Well, I don't practice in the federal arena, but we're talking 3 different districts in the state of Illinois that up until recently, handled mainly white collar types of transactions, financial crimes, and periodically some drug cases. We have 102 counties in Illinois that are responsible for, law enforcement's responsible for every violation of the criminal code in Illinois. We will have on a daily basis, I'll just use Cook County as my background. On a daily basis, you have maybe 300 or 400 people that are picked up overnight that are going through, are processed for misdemeanors and felonies. In the federal court system, you may get a handful. It's just a question of volume. You have to be able to, there is a presumption of cash bail under this bill, and that it's up to prosecutors to be able to determine whether or not a revocation hearing is something that they need to move forward with. This is not a bond hearing. It's not a trial. Under the courts, under the Supreme Court, it is just